Hello and welcome back to another episode of the Geeky Pod with Manas. In our day-to-day life, when we work in a creative field or we work in the field of research or let's say we work in the field of entrepreneurship, in such a cases, we deal with many ideas. We get many creative ideas and we also come up with some business ideas that we want to protect so that someone else do not start the same business, do not start the same research or do not submit the same research paper, same idea, and they start earning from that idea. So in order to protect all these ideas, there is something called as intellectual property. So these ideas are termed as intellectual property. Now, how to protect those intellectual property? What are the rights available as a citizen of India, and what are the various other rights available to the people of the across the world? So all this combined is our today's episode. In this episode, we have tried to discuss about topics related to intellectual property. We have tried to discuss about topics related to trademark, copyright, GI tags, and patenting. So all this combined, how to protect our intellectual property, our rights, and finally, maybe there is an opportunity where this can be for the greater good, or we can earn some profit as well from those ideas. So how to do all this? What are the different areas where patent agents are relatable? How to file for a patent? What are the various ways intellectual property can be protected? All this and more, many more, we have discussed in this episode. In this episode, we have an authorized patent agent with us. She is happened to be a friend of mine from college. She has completed her BTech, then she has completed her masters. Now she's a registered patent agent in India. Now she has tried to express her views and thoughts about this topic. Please join me in welcoming Miss Namita Mallik, with whom we had this conversation and this episode today. Hope you like this. Hope you get to know more about this intellectual property, patenting, and many other aspects. Because this is the area where there is lack of knowledge across all spheres of life. So this is the area we try to discuss today. If you like this episode, hit the like button, share with your friends, let them know about the rights that are available within the country and outside as well. And do subscribe to this channel because we keep bringing new topics and episode, and we discuss about various new aspects which is unknown to the people, and we mainly try to discuss about career opportunities and various other aspects. Thank you. Enjoy the podcast. So first of all, tell us about what is intellectual property. What is that all about, intellectual property, and why it is important for any business or any organization or any idea for that to be registered anywhere?
So basically, intellectual property, uh, we deal with this intellectual property in our day-to-day life. Daily, we are dealing with it. So basically, it is the protection or it is the property which comes out of our intellect. Whatever we create using our intellect. So those things comes under intellectual property. You can give examples such as artistic works, such as writing poems, like writing songs, lyrics of songs, music of songs, and like this is in case of uh, artistic work, and like in case of innovation, we can protect our technology. Some inventor who has given his input to making one technology, he can protect his own technical creation, and like different designs, anything which comes out of our intellect, which is our creation. So that is very different, right? Every individual is having different level of intellect, so it depends on the creativity of the individual. So all the things which comes under creation of creation under the influence of one's intellect, so these all things comes under intellectual property. So in India, we are having intellectual properties such as copyright, artistic works comes under intellectual property, and patents. Patent is one kind of intellectual property where we protect our invention or innovation, and then we have trademark, like we have business logos, business name, brand names. We need to protect those names. So this comes under intellectual property, and then we have GI tags, geographical indication tags. So this is also under intellectual property, and we have trade secrets. We have never discovered the method of preparation of Maggi masala, right? So this is one kind of trade secret they are which they are using for years and years for their business. So
Okay.
this all everything is our day to day work only. We deal with these things in daily day to day life. So this everything comes under intellectual property.
So what will happen? Let's say I have an idea or I have a business, right? So I don't patent my idea or my intellectual idea that I have. I don't patent it, but my organization or my idea grows into a big thing. Later, I find someone is copying that idea. So can I sue them without having the IP?
No, that is the main problem, that we are not having enough awareness about intellectual property. The thing is that the moment you are confident about your creation, that I have created something which is very novel in as in which has not been created earlier, or like it is very useful for the society or like some other cause, so we need to protect our invention. Maybe it is invention or maybe it is some artistic work, anything it may be. Suppose uh, Louis Vuitton, they design bags, ladies vanity bags. The thing is that if they don't protect their design, tomorrow some other bag company, they will make same prototype of their same copy of their bag and they will sell it in the market with reduced price, and people will be like, oh, we are getting reduced rate of this same product and we will buy from them only. Copied product only people consumer will start buying. The moment Louis Vuitton will start protecting their design, so they can take legal action against the company who will copy their designs, right? So anything, any creation, any intellectual property, we need to protect it as fast as possible whenever we are confirmed about the product, right? So it is very essential to legally protect our creation before launching it to the market. And even after launching also, if somebody tries to copy it, so we can legally take action against that party.
Right. So you mentioned there are various types of intellectual property rights associated with it, right? For example, patents
Yes.
are there, trademarks are there, copyrights are there. So how different each one is from it? For example, let us take patents, copyrights, and trademarks. How are they different?
So these are very interesting. So in case of copyright, so copyright is a very common word. We like, even as a YouTuber also, we have copyright. Like YouTube gives copyright strike, this and that and all. So the copyright protection is a self protection. Whenever we create something like artistic work, whenever we write something, whenever we make some music, whenever you make some content in your YouTube channel, it is auto copyrighted. Self copyrighted means whenever you are just making it, the moment you have just completed your work, that is already copyrighted. And after that, some people also try to make it legally registered in copyright office. This is specially done by big book publishing companies, like we are having McGraw Hill publishing company, like Pigeon publishing company. So they go for legal protection of the content of the book. So, and some people are there who are independent artists who write, like make content. So every time, because they are creating content very repeatedly or very frequently, for which repeated legal registration of that content is not possible. So the only right which is auto created right, or like autonomously that right is transferred to the creator, is the copyright. And one of the thing, like any artistic work, suppose I have sculpted one portrait, like I have made one statue, I have sculpted one statue, though the so the artist who makes the statue is the creator of that uh, art. So that comes under copyright. So we know that copyright we will be having copyright over content, writing, music, anything. So, but the thing is that statue is also copyrightable. It is a very rare known fact. So the the artist who makes sculpts the statue, he is the artist of that art. So it is of copyright. Let's come to trademark. So trademark plays a big role in this business industry. Any kind of brand. So whatever brand you take, name of any brand, the brand name. Suppose Bata. So the name Bata is the means like I will call you Manas. So you are a package of different skills, right? So I cannot call you like you are a software engineer or you are a computer science engineer. Oh, computer science engineer, please come here. So to identify who the person, I have to call you Manas, right? So to call one business identity, you have to mark that identity with a particular name, right? So that name is trademark. So in case of trademark, it can be name as well as it can be logo also. So in Bata, you cannot find any logo of Bata. The name itself is only trademark also, logo also. But in case of Adidas, you will see there is a logo of Adidas, three
Right.
stripes of Adidas. In case of uh, Puma, you will see one.
Right.
Sorry, in case of Nike, you will see one strike of
Right.
Nike. So Nike itself is a trademark, and the strike is also a logo of Nike.
Okay.
Fine. So the logo is also a trademark of Nike. If you wear one Nike shoe, you will not have the word Nike written over shoe. You will have just the strike on the shoe. So
Correct.
that strike is a representation of the brand Nike. Fine.
Okay.
So these are trademarks. Fine. In case of uh, patents, we have in case of patents, uh, patents what it does, it's like it depends on totally technology, fine. So in case of technology, so any technology which is very new or novel and it is having some uh, commercial application and it is not previously known in the art, so that kind of technology can be patented. So the patent, this is what we call patenting of technology. So after you are patenting your technology, so you are the sole owner or legal owner of the technology, so that somebody else cannot copy your technology. So these are the main basics of uh, copyright, trademark, and patents. We do have many other IPs also. We will discuss
Sections.
it further.
Okay. Right. So let's say as part of a new technology, I have a mobile now. Our mobile is if it falls down, the glass breakage chances are high. So I design a technology where as soon as it falls down, airbag will come out of it. Just saying, just some random thing. Now
Yes,
I
yes,
want to
yes, yes.
patent it, right? Now after patenting, some company, let's say Nokia or Samsung, is trying to use that same technology for some reason. So
Yes,
what kind of
yes.
rights or what kind of perks or liberty I will have in terms of, let's say, licensing or monitoring gain? What are the benefits I will get because I have patented it?
Yes, the main thing of patenting is that you have legal rights over the technology, right? So, uh, what it does, it, generally we call patent right as negative right, because it suspends other participants in the market from using the technology as well as commercializing the technology. So, whoever wants to use your technology which you have patented, so they first of all they need to license your technology, and the licensing terms are based on you and the other company who wants to use your technology. So some licensing agreements are made, and accordingly you will get the royalty of production they are making use of it. So you
The
can
terms
have
can be defined
monetary
by me
gain.
because I am the
Yeah,
patent holder.
yes. Because you have put all the effort to make the invention. So you know how did it cost you to make that invention? So depending on that much effort and that much cost that made you to bring that invention into the table, so all the matters uh, is, will lead to the licensing agreement with that particular company.
Right. So now this applies to medicine world as well, pharmaceutical world. Now, when COVID struck us, right? So that time also medications and vaccines were born. Why that time a particular company did not have monopoly of building the medicine?
See, in case of emergency conditions like COVID or any other emergency condition, in that case, uh, generally government has a power of using your invention, or like he can overtake your invention. So generally in case of COVID time, it was a totally emergency case, and you cannot use your uh, negative right over patents, or you cannot make any monetary gain over your invention, which is useful for the existence of humanity, right? So for that, government has certain uh, sections or rules which they can implement on the owner of the patent, and government can make use of that invention in case of emergency. So that is what happened during, like you have seen, we have taken Covaxin. So Covaxin was made by Bharat Biotech and ICMR. So they couldn't make that monetary gain because it was an emergency situation. So government has to take action, and this is all in hands of government.
Okay. So now so far we understood that there are various kinds of intellectual property rights, and we can apply for those as well. Now, there definitely may be something that we cannot patent, right? Some things like cannot be patented. However, you try. What
Yes,
are
yes.
those areas?
See, under Indian Patent Act 1970, so there are various exemptions from patent. So anything like I have made something, some invention, it might be patentable. It is not that. So there are various exemptions which we cannot patent. So I will mention few things because there are list of things which cannot be patented. So like if in case of we have seen medical like technology, you know, like we have seen many advancement in medical technology. So if if some inventor who he suppose he makes one technology of one cardiac surgery, like robot technology which can accurately and precisely do cardiac surgery, groundbreaking technology where there is no human intervention and all. So in that case, he cannot patent the technology because this is a method of treatment, right? So any method of treatment is not patentable in India. Okay. So you can rather patent the device. You can rather patent a device which helps or assists in uh, means treatment of a medical condition, but you cannot patent the method of treatment. Okay. And suppose some traditional treatment techniques are there, some traditional medicines are there which are already there in the traditional knowledge of indigenous people, or like some particular community of people. Those things, suppose Ayurvedic medicine, ashwagandha, which can ashwagandha, tulsi, this thing and that thing, which is already known to the traditional knowledge of people. So those things cannot be patented. So those things cannot be patented as a drug for relieving this thing, this medical condition, and this medical condition.
Okay.
And uh, anything. Suppose I have made one umbrella, in innovative umbrella, which is having a torch integrated with the umbrella, right? So like whenever there will be some dark, the umbrella will be automatically, it will be opened, and in case of it faces some dark condition, the torch will automatically glow based on LDR conditions. So that cannot be patented because it is just an integration of one innovative torch and one innovative umbrella. So
Right.
it may be maybe I can think that, oh, this is so innovative idea, I can patent it. No, I cannot patent these things. And anything which is naturally existing, which is naturally like any natural laws, like discovery of natural law, like Einstein or any other scientist who have discovered natural law, so those things are not patentable.
Okay.
And anything which is like, if someday or any other day, if I discover or if I invent one technology which helps in theft, which helps in hacking, which helps in which is breaching privacy of public,
Hmm.
and like which is morally not correct to public, those kind of
Okay.
inventions are not patentable in India.
Okay.
So these are some of the examples. So there are a
Understood.
list of things which are not patentable.
Now, in general, right, it is said that software as a product cannot be patented because it contains similar kind of a coding we may have taken from some other source, we may have taken from artificial intelligence nowadays. So, but in software field also, I have seen patents and IPs are being taken. Right. So, which are the areas when any software product will be considered as a original one, and which are the areas where it will not be patentable at all?
See, in case of softwares, generally the IP protection, which is according to standard protocol, softwares are generally copyrighted. So you might have seen all the softwares whenever you see the means user interface of the software. In
Below
downwards,
it
it
is
will be
written.
written copyright this thing, copyright this thing, that. The thing is that the algorithm which we are using for executing the functionality, this is basically copyrightable, but the algorithm is not patentable. What is patentable is that the function which is being provided by the algorithm. Suppose my algorithm is giving me a functionality of detecting cancer cell, right? I have a AI integrated AI ML camera, which is using some advanced algorithm which can detect cancer cell, right? So the functionality of the component of the camera, which makes it efficient enough to detect cancer cell, that functionality is patentable. But the algorithm which is leading to the functionality of detecting cancer cell is not patentable. That is copyrightable.
Okay.
So that's why in case of software, in case of list of in our exemption list of patent invention
Right.
also includes software algorithms. So we cannot patent software,
But software companies as a
but
whole
we
can
can
get
patent the.
trademarks
Yes, obviously they can get trademark, but not of the algorithm. Company
company
name can
branding or
get the
other.
trademark.
Right.
Yes.
Okay. So now let's say I have an idea that I want to patent. So I live in India. I'm a citizen of India. I have an idea or business idea that I want to patent, and I don't want to tell others yet before patenting it. So how do I proceed for patenting that idea? What are the steps involved as per the Indian law?
Okay, so for so the patent filing process is a very important process. So here multiple people are eligible for this. Like being a single inventor, the process is something. Being a student, the process or the owner is someone else. And being a company or being a means small entity, big entity. So it depends on multiple uh, means based on the party who is going for patenting, right? So first of all, for patenting something, we cannot rush for patenting my invention, as well as we cannot delay for patenting my invention. So if we rush for patenting my invention, we might have an opportunity of infringing someone else's invention, right? or if we do some delay in filing my patent, someone else might file my invention which I have been delaying for filing patent. So I have to be optimal in filing my invention. So I cannot make rush as well as I cannot delay. So to properly, I need to find that proper time when I can file that invention. So for that, first of all, I have to check whether my invention is patentable or not. So many of the researchers or many of the you know means lab students or research students who are doing work in patents, they don't even know whether their research work is patentable or not. So we have to first check whether my invention is patent. As I have said, the exemption list of patentable inventions in India. So whether it is patentable or not, first we will check that one, and after that we will check novelty of the invention. Novelty as in whether the invention is novel all over the world or not. My invention is needed to be novel as well as it is required to be commercially applicable, and the invention is required to be like I have made one invention. It should not be obvious to the person skilled in the art. As in, suppose I have made one invention uh, like automated device which can do some work. So, some person who is expert in that field in automation, it should not be like that the invention which I have designed or which I have created, it should not be obvious to the expert person in that field. That person might not say that, okay, fine, you have done this, but it is very obvious that it will do this thing only. Okay? So we cannot patent that thing also, which is very obvious to the person skilled or expert person in that field. Okay? So we have to check checklist. We have to check all the list whether it fulfills the criteria or not. Then we go for the filing stage. And in the filing stage, we draft the complete specification of patent. And if suppose I have an invention, but I know that invention is patentable, I have done market study, I have done research, and I know my invention is going to be patentable, right? But the thing is that my results are yet to be in my hand. My results are awaited. My the results of my invention or the results final output of my technology is awaited. In that case, I can file one provisional patent filing. Provisional as in I can priorly file my invention so that if somebody else is working in that invention, he I can take the priority of my invention before someone files that invention. Okay. So and after that, one provisional filing, what it does, it gives me a protection so that whenever my output is in my hand, in during that period, somebody else doesn't file patent for that. Okay. So in that case, the protection is in my hand. So one way is that I file a provisional patent application, and then within 12 months with my awaited results, I file one complete patent application. So once we file complete patent application, it has various, process and steps. It has various steps. We file and then it gets published and then it goes for examination, and that after examination from the patent office, we get objection regarding means our invention, and then we have to reply to the objections, and then after that, if required, some hearing is also done, and after that hearing, the controller takes decision whether he has to grant that patent, or he might not grant that patent also. If he doesn't find it suitable, that it is not patentable, then he might not grant patent. So this is the basic process of filing one patent in India. One more thing is that if I file one patent in India, it is not required that it is patentable throughout the world. So I have patent rights are generally territorial rights. I file in India, so I have protection only in India only. Fine. But the thing is that somebody cannot make patent of my invention in some other country. He might use the invention, he might make a copy of my invention, but he cannot patent my invention because already my patented invention is out in public domain. So we take patent is granted in lieu of disclosure of my invention. So I have patent, but the thing is that my patent, every everything of my patent is already disclosed to the public. In lieu of that, controller gives me a patent grant. So if somebody who is out of the territory of India, he wants that, okay, fine, I will make that invention. I will not patent that invention, but I will copy that invention by studying my patent document. He can make it. I cannot legally take action against that person, somebody who is outside my country. Fine. So I can only take legal action against somebody who is either using or copying my invention in the territorial area of India only. If I file or if I get a patent granted in India.
Okay.
So patent protection depends on territory. So for multiple patent rights in multiple countries, we have to file multiple patents in multiple countries.
So there is no central global patent office or somewhere I can go and submit my data so that it gets globally patented.
Uh, yes, we do have a system that is called international filing. Fine. We don't have anything called international patent, right? We don't have anything known as, so in coming days, if somebody is advertising as in the global patent, international patent, nothing called international patent, nothing called global patent. Fine. But we can file patent internationally so that I get a protection over multiple countries. Fine. At one filing. So there is a system which is called PCT or Patent Cooperation Treaty patent filing. Okay. So in that, according to that treaty, so if I file once, I get a protection of over 135 countries in the world at one filing. Fine. So 135 countries, those 135 countries have signed one treaty, that is Patent Cooperation Treaty. And amongst the 135 countries, India is also one country. So in that particular one filing, I get a protection over 135 countries. That too, uh, there are some further steps in going to each and every country, but the at one filing, I have a prior means prior filing right uh, with one filing to 135 countries. But after that filing, I have to individually file also in those particular countries. But the thing
Every
is that,
country.
yes, and that is called national freeze filing. So first,
Okay.
in case of international filing, first of all, what we do, we file for PCT international filing. With that filing, we get one, filing date. That filing date is our primary date of protection. That from that day, I have a protection of over 135 countries. Okay? And then if I, after 30 months from that date of filing, I have to individually file to each and every of 135 countries or whichever country I want to file. Suppose I
Okay.
want to file in US, then after 30 months of that first international filing, I will file to US. I want to file in Europe, I will file in Europe. I want to file in Japan, South Korea, India, Bangladesh, anywhere, I have to individually file my patents in that individual countries. But the protection date of invention is that the day of international filing. The
Okay.
the day on which I have done my international filing, I get a protection of my invention from that day to over 135 countries. Now it's my choice
Okay.
that I will take whole protection in a particular country.
Understood. Now, with that point only, so the tenure of the patent applies from the date of filing, right, in the international patent system. Now, how long is a patent valid? Patent, copyright, or intellectual property, or trademarks? How long is the validity for each one?
See, this is a very interesting question. Patents, sometimes we feel like okay, it is patented, matlab, it is patented, then we don't have any right over it. So whole like throughout lifetime we have to believe that that is patented. It is not that. Patent is having a term of 20 years, like the date on which we file patent application. From that day, if my patent is granted, then we get a patent grant term of 20 years from the date of filing. So only up to 20 years from the date of filing of my patent, I get a right over that invention. And after 20 years, I cannot legally claim right over my invention. Like after 20 years, if somebody is using my invention or if somebody is manufacturing my invention, I cannot take legal action against that party. But in between 20 years, anybody who is using my invention or who is manufacturing my invention, I can take legal action.
Okay, let's say you have done one patent for one of your invention, and you got 20 years right. In 21st year, can I patent it by my name?
No, because the thing is that patent is granted only if your invention is novel, right? So one novel invention is granted only for 20 years. After 20 years, it is not even novel also. So you cannot patent. First of all, patent right, once it is granted, it is for one time only. It's like one
Understood.
time OTP password. It cannot be renewed or it cannot be transferred.
Understood. Now, in India, right? So to file any patent, there are various way. Like you are one of the patent agent, right? So through you also we can file patents. So how much does a single patent cost in India, and where can I get help to file a patent? What are the various ways? I think awareness is very less in this area.
Yes, yes, yes. Very, very important. Very important. The thing is that uh, it depends. It depends on. So I have previously mentioned that there are multiple types of uh, patent owners. Somebody is like individual inventor. Somebody is like small entity, like MSME enterprise. Somebody is like big entity, like big R&D of one company. Like somebody is startup. So there are different rates of application fees set by Indian government. So in case of individuals, the fees is something. In case of startup, fees is something. And startup and individual is considered same only in India.
Okay.
For large entity, it is something else because they are commercial bodies for large
Hmm.
entities. So the application fees differs for this kind of parties. But here comes the thing: if you approach one patent agent for filing your patent, so depending upon the entity you are, like if it is startup or large entity, it depends, and the invention you are taking, it depends on the invention also. Like if the invention is of means more complex in nature, more means complex technicalities is inside that invention, it might take more time as well as more work for a patent agent to understand that invention and legally draft that invention for filing that invention. So usually patent agents charge uh, you know freelancing patent agents charge 20,000, 25,000 for a single patent application based on the entity. So if it is individual entity, he or she can charge 20, 20,000, 30,000 per application. And I'm excluding the application fees. Okay, this is
Understood.
the only charge for filing. And it depends, like if you want consultation from patent agents, so it depends, like if you want, I need patentability search, I need prior art search. After that I want to file my application, because suddenly I cannot file if it gets infringed by somebody. So that consultation, that searching, eh, patent agents also can do this kind of things. So the price can go plus minus with that rate. And uh, subsequently, for filing, we have subsequent actions after filing. Like once we have filed patent application, we have to file for examination of patent. And after examination of patent, again we have to reply to the objections from patent office. So these are subsequent actions, you know. So for the subsequent actions, they may charge accordingly. So average one patent filing may take 25 to 30,000. I'm talking about very average uh, means
Understood.
rate.
So, so in India, right? So, what are the major mistakes any individual does while filing a patent? Like hiding some information that they think is maybe crucial later. Because of that, the patent gets registered. Is there a way that I do some mistake, right? And I file the patent, and later I correct it to get the patent for it. Can I do that, or it's not allowed?
See, the thing is that first of all, the patent examination is done very thoroughly, so that if in case you know, controller of patent office, he is not satisfied with your results, he may take consultation from scientific advisor. You know, we have scientific advisor in patent office who can give uh, consultation regarding complex patent applications. So if they find that you have done something, means you have done some error, so there are some sections are there using which you can correct your errors. Controller can give you the power to correct those errors, whereas controller himself has the power to correct your errors according to you. But the thing is that it should not cross the domain of your invention, or it should not cross the. Sometimes it's like, I have done one invention, it is having one you know, mm, uh, ultrasonic sensor. So I want to change that sensor. I want to fix some other sensor. That you cannot do. So you can increase or decrease the efficiency of ultrasonic sensor. Like you can change the correct the data of the ultrasonic sensor, but you cannot change the ultrasonic sensor. So, and if in case you want to modify your invention, so if your first invention is already patented, your patent is granted for your first invention, and now you are having some extra idea with your previous invention, you want to integrate something, you want to add or modify something in your invention. So for that we have patent of addition. That is called patent of addition. So I want to add a modification to my existing patent, so I can file for patent of addition. So these things are very common in, you know, big companies like uh, who makes devices, and like after a few years they come up with an advanced version of their device. So
Okay.
if they have already patented that device initially, so they file for patent of addition. So patent of addition and main mother patent, the tenure is same. It's not that if I file patent of addition after
It
you
will
know,
get
10
increased.
years, 10 years of my mother patent, so I might get extra, you know, 20 years.
10, 20
Nothing
years.
like that.
Yeah.
No, no, no. The
Okay.
tenure will be same as that of the mother patent.
Parent. Okay.
One
Yeah.
more, one more thing I would like to add here, that the problems which we face during patent filing is that there are many research students in uh, technical institutes, mm, suppose like masters or PhD students. they don't know when to file their patent. The thing is that they don't know when to file their patent. There is very less awareness in this case. The thing is that whenever some student is confident that my work is patentable, they should immediately consult one patent agent or some uh, consultant who can give them consultancy regarding filing of their application, because every research work they are doing, they are publishing in SCI journal, or they are publishing it in some conference, so that publication of their project in some journal or in some conference is a big mistake before filing patent application. So first of all, if I want to have patent of my invention, or if I want to file patent for my invention, before publishing my work in a journal or before publishing my work in a conference, first thing what should I do is to get a patentability search whether my invention is patentable or not. If my invention is patentable, first I should file one patent application. The day I have filed one patent application, the next day I can go for my journal publication as well as my conference publication. No issue in that. Nothing issue in that. No patent application will be no patent application will act as a plagiarism to my conference publication or my journal publication, because patent application gets published after 18 months of filing,
Okay.
after 18 months, which is 1.5 years, so in between you get your journal published, you get your conference published, nothing wrong in that. So if I file my patent, suppose today is 27th of April, so I am filing one patent of my invention, and now I need to file for my journal as well as my conference also. I have filed my patent application on 27th of April 2025. Now I will file for my journal. I will file for my conference. No plagiarism will be there, since my patent is only filed. It is not in public domain. It will get
Okay.
published up after 1.5 years, which is 18
Hmm.
months. So
Wonderful.
no plagiarism will be there. But once my if I don't file my patent, and once my journal gets published, and once my uh, conference paper gets published, my patent application is total at loss. I cannot file for patent because my work is already out in public domain, already out in journal, already out in conference paper. So my own work, my own journal publication, my own conference publication will act as a prior publication of my patent work.
Okay. So let's say you are in Delhi, I'm in Tamil Nadu, right? So we are doing study in the same field. We are in different colleges, right? Same field, same topic we are studying. Now, let's say you file for patent today, today's date, and I also
Mm,
file for today's date. Our topic is same.
mm,
Our research
mm,
area also same. So there is a chance that our idea also may be same. So in
mm.
such a case, who will be eligible for the patent right? You or me? In which condition it will be applied? Meaning, if I am not able to submit valid proof, will it go to you? Or if you are not able to submit valid proof, it will come to me. Which is the one?
See, generally, what happens last time it happened that uh, someone gave some, clock timing, that I have filed it at 5 o'clock, I have filed it at 10 o'clock. Okay, so that kind of clock timing is now no more considered. Only the date is considered. So if if then also the patent examination goes through rigorous examination. So if they find it like two patents are clashing, they will match the claims. In patent we file claims. So if there is some difference in your invention, in claim of your invention and claim of my invention, then those two invention will be considered uh, apart, because you are claiming something different. I'm claiming something different. Maybe the invention is same. Maybe you have invented some camera. You are claiming the lens part. I am claiming the automation of the camera, but the invention is of the camera, the photograph capturing device only. Fine. So in that case, this kind of differentiation goes on. We check for the claims. So if the claim is different, then the invention will be considered apart. It would not be considered as same claiming. So it might be
Okay.
different. So there are very rare chances that my claim and your claim may get clashed. So there are very rare chances.
Okay. Now, let's say nowadays AI is at the boom, right? So it's growing like anything. Now AI can generate ideas also, no? So we can manipulate AI to give us some ideas, which is a combination of many ideas, and it will feel like it's a real one. So how the patent system ecosystem is, you know, well equipped enough to find such combination ideas?
So the thing is that it is a war. Now it is a war. So kind of like initially when the patent laws and IP rights were framed, those time artificial intelligence as well as digital exposure were not of that level. So the laws were framed in a way so that we can means physically or like without digital interpretation or digital intervention we can protect our invention. But the thing is that now today we are having AI ML. So today we are still at a phase of reframing our laws in a way that we can build one robust structure, so that we cannot neglect the intellect of one inventor, as well as we cannot the assistance of one artificial intelligence. So keeping both in mind, we are trying to reframe our IP laws so that
Okay.
both the things will be considered.
Thank you so much for watching till the end. If you like this episode and if you have gained some knowledge from this episode, don't forget to like, share, and subscribe to this channel. And like this video because it reaches more and more people. If you like the video, share this video with your friends and colleagues and various other social media platforms so that they also get to know more about it. Thank you. Thank you for supporting.